Hello, everyone. This is Ankar Gate. Welcome or welcome back if you're joining us again. So this is the fifth of six sessions that we're doing on Ayn Rand's political philosophy. And tonight we're going to be talking in some more depth about Ayn Rand's view of property rights, their source, nature, the importance of establishing them. So a variety of issues in conjunction with how she thinks about property and the right to property. And I'm joined again this evening, well, it's evening for me, not evening for everybody, by Greg Salmieri and Agustina Vergara Cid. But, well, do we have to do any other, I see people are still, for me today, the Zoom is populating very slowly. So I see people are still joining.
I see about 17 people on there now.
Yeah, okay.
Yeah. I guess we could just say about procedures. We have posted some questions as we do on Facebook. There has been, I think, this week some really good reactions to them, a lot of good comments and further questions from you guys. So we're going to spend a lot of time today dealing with those, or structuring our discussion around those, rather, I should say. Also, if you want to ask more questions now, if you're on Zoom, you can post them in the Q&A feature of Zoom, and we'll select the ones that seem relevant and like we have time for and address them. Or for just quick things that are follow-ups on what we're saying at the moment, you can post them in the webinar chat. If you want to ask a question by audio, you can raise your hand in the participants panel, and we haven't had too much of that. We tried it once or twice, but it would be fun to take some audio questions.
One comment about that, Greg. If someone wants to ask a question via audio, please make sure that you have the latest version of Zoom, because otherwise you won't be able to ask the question via audio.
And also, if you're watching via Facebook, you could type in, if you want, a question there. We're not monitoring that as closely, but I think Augustina at least has an eye on it. I'm having trouble fitting that onto my screen. But you know, those are the lower priority questions to get to, and they're a little bit time delayed too. Okay, so that's all the matters of procedure for today. Looking a little hard to see. We have a handful of people watching on Facebook, more people watching on Zoom. It kind of oddly faded up over the course of the session last time. But anyway, we're getting really good engagement in the comments on the Facebook channel. And we wanted to start actually today, before we get to our main topic for today, with a question that that Eric asked as a follow-up question to some of the material in session 2. But that actually, well, one, it's a very good question, and two, I think it helps us get into one of the themes that we're going to be addressing today, which is the role of government and the need for objectivity in defining rights in different realms, and particularly the right to property. So, Ankar, do you want to start with Eric's question?
Sure. So I'll quote a little bit from what was posted, or what Eric posted on the Facebook group. So, quote, according to Rand and then our edition, the objectivity of law, end of the edition, is something more than epistemic objectivity. Laws do not merely need to be formulated in accordance with the facts about human nature that give rise to rights. They also need to be enacted such that, and then he's quoting Ayn Rand, quoting Ayn Rand, men know clearly and in advance of taking an action what the law forbids them to do and why. Close the quote from Ayn Rand. Continuing Eric's quote, this basically means that to be objective, man-made laws must be made to be akin to laws of nature. They must be, in a certain sense, out there for everyone to observe. Close quote. Yeah, I think this is right, though I would not put it as something more than epistemic objectivity. I think the notion of objectivity is always essentially epistemic, though. So I think what is meant here is something like in an individual, we're talking about an individual knower trying to grasp the facts of reality or something like that. So strictly, if you're talking about the advice epistemology gives to you as an individual for how to pursue knowledge, and essentially if you're alone on a desert island. But I think objectivity always has an epistemic component, and it's central. And if you see the quote from Ayn Rand, men know clearly and in advance of taking an action. It's the stress on know, or at least that they can know. They're in a position that they could know what the laws are, what's forbidden to them, why, how force will be used against them if they commit certain actions that are defined as trespassing or violating a person's rights. But she uses the concept of objectivity in more contexts than just the knower on a desert island, or and you might think of it as that's the fundamental perspective in objectivism. Last time we were talking about the issue of socially objective value and philosophically objective value, and notice there it's even, and before that we were talking about the objective, subjective, intrinsic subjective approach to values. And there, so it's in a wider context, but part of what she's stressing is that values require knowledge, the discovery, forming, and application of knowledge that an individual has to do. So I think the issue of knowledge is always connected, but there's different contexts in which one can think about objectivity. And when we're talking about the organization of a social system, it's social objectivity that we're talking about. And so part of that, it's knowable here means to everybody. So it's in principle knowable to anyone, and it's in principle knowable to everybody. Therefore, that everyone understands and can know in advance, this is how force will be used, and not just this, it's going to descend on me, but this is how you guys are going to be using force. This is how everyone in the society can use force. This is what will be considered legitimate and then illegitimate uses of force by anyone in regard to anyone else. That this is all known, codified in regard to the law. And I think it's right to put it to, it's akin to a law of nature. It's one of her examples is, I think I referenced last time, it's like a robot functioning. But then, so then the question was that, well, again, quote from Eric, I cringe when objectivist intellectuals seem to equate the private with the arbitrary in discussing government. Or are they using arbitrary in a different sense than ordinary epistemic arbitrariness? If they are, I think it would be helpful to make this explicit. And I don't think I actually don't think there's an ordinary epistemic sense to arbitrariness. I think the way objectivism uses arbitrary is a little, distinctive. It's a term of art, in effect, I think, in objectivism. And it's contrasted to that when you proceed completely non-objectively or in disregard for the norms and guidance offered by the concept and principle of objectivity, you're proceeding arbitrarily. And an individual can do that in the supposed quest for knowledge, but objectivism's view is he's not interested in knowledge at all. At most, he's masquerading as being interested in truth and facts, and he's proceeding arbitrarily. He advances or advocates arbitrary ideas, arbitrary possibilities or hypotheses or conjectures, that they're completely detached from fact and any attempt to know the facts. And I think then the use of arbitrary when we're talking about objectivity in a social context is it has to be thought of in that context. There's a disregard for what the norm of objectivity requires. And here, so part of what she's arguing, I think, in regard to the nature of government, is that what objectivity requires to put force under objective control is how she thinks, is one of the ways she formulates what the task of a government is doing. It has to be in a form where, to go back to what Eric quoted before, that it's known to everyone or knowable to everyone. And it's knowable how everyone is going to use force, and that properly a law and that the government has a monopoly on law makes that possible. So how force will be used is known. And she uses this kind of formulation. And I think I used something like this in the session 2 that Eric's making reference to, of it's not an equation of the private means arbitrary, but rather that in this context, the private would be arbitrary. And here's the quote from The Nature of Government. Quote, "The use of physical force, even its retaliatory use, cannot be left at the discretion of individual citizens. Peaceful coexistence is impossible if a man has to live under the constant threat of force to be unleashed against him by any of his neighbors at any moment." And then notice this, whether his neighbor's intentions are good or bad, whether their judgment is rational or irrational, whether they are motivated by a sense of justice or by ignorance or by prejudice or by malice, the use of force against one man cannot be left to the arbitrary decision of another. Close quote. And notice the use of arbitrary there. And it's here, it's in the context that the private use, even by a person who's proceeding rationally, is concerned with justice, is arbitrary from the standpoint of the other individuals in society who are trying to live their lives, understand their rights, what it means for them to be protected when trespassed, what actions will result in force being used by the government in retaliation against them. So all that they have to be able to know in order to navigate their lives. And from their standpoint, your action in the private use of force is arbitrary to them. And I think that's what the point that Ayn Rand is making and why she uses arbitrary in that context.
A couple of references on this, or one main one that I think would be helpful. In the new book that's come out, a new textbook on Americanism, edited by Jonathan Honig, it is the press for that book, or the marketing for it, buries the lead, I think. The most interesting and important thing in the book, from my point of view, I should add as one of the contributing authors, is that in addition to some good pieces that are new by, me, Ankar, and a bunch of other people, Alan, Don Watkins, there's and in addition to what it's named for, which is the textbook on Americanism that Ayn Rand wrote part of back in the 40s, there's also published for the first time, because the old textbook stuff had already been published, excerpts from some sessions Ayn Rand had on political philosophy in the 70s. And so new unpublished Ayn Rand material of her discussing with some professors and grad students and such issues in political philosophy. And there's a lot on, well, wouldn't an anarchist say this? And what do you think about succession? And what about the rights of vigilantes to do this or that? And do they have rights? And there she talks a lot about objectivity, what it is and isn't objective to do when responding with retaliatory force. So to get Ayn Rand on this, in addition to what she says in The Nature of Government and elsewhere, look there. And then the other place where Rand uses the term arbitrary in connection with government officials and their decisions are arbitrary, is where she uses it a lot, is when she talks about non-objective law that gives power to bureaucrats, particularly executive office holders, but also laws that make Congress people, or precedents that let Congress people give out grants and so forth for things. She talks about when you have these kinds of powers, which there's no objective basis for, the problem isn't that some corrupt or dishonest officials will use them in some biased way or corrupt way. It's that there's no honest way to do it. If you want to try to give out grants for scientific research in a way that's in the public interest, given that in the public interest is a non-objective term, there's no way to do it other than you pander to a voting bloc, or you do what you personally think is best for the public, but you don't, or what you personally think is best, regardless of whether the public wants it or not. There's no way, in her view, to do that objectively, even if you're trying. And so any decision will ultimately be a matter of your caprice. because to be objective, you'd have to be looking for a standard that's authorized in law, that's proper, authorized in the facts that give rise to the need for law, that's proper for a government official to do. And there aren't facts like that authorize any of these actions. So two questions that are coming up on the chat. Someone asks what the source was that I was referencing, that you could look up Ayn Rand's views on this, and that has new unpublished material by her. And that's a new textbook on Americanism edited by Jonathan Honig, and I think Jonathan's here tonight. And Steve is asking, Steve, who by the way asked a lot of really good questions and made a lot of really good points on the Facebook group that we're going to, I think, engage with later today, is asking now, is what we're talking about with acting arbitrarily compared to the pragmatist idea of public reasoning theories of truth? Only in this respect. I think if you're talking about the idea that when you're engaged in public reasoning, you have to be appealing to considerations that everyone in the population can get on board with, because they're, secular principles based in reality that everyone has an interest in, or they don't say based in reality, but the reason why everyone would have reason to go by them is that they're based in reality, as opposed to reasoning on the basis of your religious beliefs or something like that. And so that in discussions of public policy, all of your reasoning should flow from these kinds of beliefs. Otherwise, it's subjective. In that sense, I think there's a connection. I don't know of any other uses that you might have in mind. Okay, so with that, let's move to the material that's new for today. And we looked at two articles, both in the book Capitalism, the Unknown Ideal. One of them is the property status of airwaves, and the other is patents and copyrights. And what the articles have in common is that they're both about property, and they're both applying property rights to cases where it's, some people don't think property rights apply. Hardly anyone thinks they apply to airwaves. And patents and copyrights, well, some people think they're not a real right. Some people think they're illegitimate altogether. Other people who think they're legitimate don't think they're properly a property right, but something else. But Rand views them as a property right. And so by looking at these two pieces together, I think her views on the specific issues raised in them are really interesting. And but more broadly, I think we get a sense of what her approach is to the concept of property and the idea of a property right, and what justifies it, and what the government's role is in regard to property. So what I want us to start with doing is talking a little bit about the issue of property, what we learn about property from these articles, and especially from the airwaves article, that's more general than its application to the case of airwaves or to the case of IP. So just talk about property rights in general as informed by these articles, and then zoom in a little bit to the airwaves case and then to the intellectual property case. So we can start with the issue of why does Rand think there is property? What things should be property, and why should they be property? And one, maybe a couple of people quoted, there's a kind of signal statement on this at the beginning of the property status of airwaves article. So let me read it out. Quote, any material element or resource which in order to become of use or value to men requires the application of human knowledge and effort should be private property by the right of those who apply the knowledge and effort. I'll repeat that again because I think that's the real central statement. Any material element or resource which in order to become of use or value to men requires the application of human knowledge and effort should be private property by the right of those who apply the knowledge and effort. So that's the standard for what should be property and why, right? If there's something, it's a material resource or element, we'll talk more about what that means, particularly when we get to intellectual property, which is valuable to people, but only because knowledge and effort has been applied, ought to be owned. And ought to be owned by who? By the people who apply the knowledge and effort. Why? By their rights. And if we go back to what we read about property in man's rights, the first article we looked at, right? There's the idea that it's the right to create, use, and dispose of. So it's the idea there are values that get created, things that become valuable because we do something. And then the person who's done that, who's made something valuable or made a value, brought it into reality, made it valuable, by right of having done that, gets to keep it. He has the right, therefore, to use and dispose of it. And Steve said, or Anka, did you want to come in here?
No.
Steve said in the Facebook, I think nicely, the emphasis on action provides the concept of a link or tether between the consequences of productive action and the human life form, since Rand's view of rights rests on the need to perform value-significant actions. And I think that's right. There's a human way of life, which is the way of life that human beings live by, that we survive by. It involves acting in a certain way, because a life is a process of action. And the action is, or a main central component of the action, is creating, by reason, identifying things that would be valuable to us, that would help us live, creating them, and then consuming the things that we've created in ways that help us to live. And so it's all about action. Rights are about the freedom to act, and this is the freedom to take the actions needed to create values, and then the freedom to use the values you've created, or to use the material elements you've made valuable by your productive work. So I think that's the kind of essence of the right abstractly, and it tells us what kinds of things there should be property rights in.
Just one quick point to tie into something, another thing, and we didn't discuss this too much, but I think it's important for getting Rand's perspective here and on political philosophy and on capitalism. In What is Capitalism, she says something, I forget the exact formulation, I was just looking for it, I didn't find it quickly, about that what capitalism institutes is the principle of justice. And that so it's a very moral perspective on it. And if you think of other political philosophy and philosophers, such as, for instance, Rawls, but Plato, it's all about justice. And it's rightly, I mean, there's a reason for that, because that's in your interactions with other human beings. This is the moral principle. And then the question is, what is justice? But she views a proper principle or conception of justice as being implemented by the social system. And I think that one crucial aspect of its implementation is the right to property, that what it preserves is the person who creates is actually the person who benefits. And if justice is about giving or recognizing what each person deserves and acting accordingly, that there's a crucial element of looking at the capitalist system and its property rights as it's an aspect of the implementation of justice.
Good. So if there are any sort of really general questions now, you can put them in the Q&A or raise your hands about them. But I think there are a lot of good general questions that came up on Facebook that kind of motivate a lot of the other issues that I think we're going to want to talk about. And we have this general idea that if something becomes valuable through human activity, then it ought to be private property and owned by the person who makes it valuable by his activity. That's what the principle of rights applies. It says, but then what does that actually mean? How do we actually implement that? So Alex, Al, and Steve all asked questions that kind of raise some of the difficulties that come up when you try to apply this and think, well, what does this mean in practice? So Alex asks about a tree in an unowned area. He says it's not privately owned initially because no application of human knowledge and effort was put into it. But if someone comes down and cuts down and chops it up, first come, first serve. So the first person to come there, cut it down and chop it up into firewood, it has then become private property, he asks. And I think, yeah, that's right. If you have a tree in an unowned wilderness and somebody comes and cuts it down and chops it up, the firewood that is produced by his action of chopping down the tree is private property, and it's his. He then asks, if I plant a seed that grows into a tree, does that tree become my private property? And would this stop someone from claiming all the trees in an ownerless area as private property simply because he cuts down trees? And now Paul is asking, what about the tree next to the one I chopped down? Or maybe the one next to the one I planted? Well, what I think this points to is I don't think if I just plant a tree, it's my property. I don't think we know enough to know that yet. And why not? I mean, what more would we need for it to be my property than that? Does anyone have any thoughts? I mean, part of why I don't think it's my property is because there's no way to be clear on this. And there's no way to be clear on the question of, well, which trees are mine? How can you even tell which trees are who? Someone wants to play the Rush song, Trees. Someone's asking if I care for the tree. I don't know if he means if I love it or I come and water it. But what are we imagining happening here, right? Well, think about it this way before you think about, is there a right? Would it be wrong of you to cut down this tree? I've planted it. Is it wrong of you to cut it down? What about the tree in the ownerless area that you cut down and became your firewood? Do you know nobody planted that 50 years ago or 10 years ago who's hoping to come back and he's weeded it and he loves it like Paul and Gordon seem to love the tree they're on about in the chat? There'd have to be a way for me to, I would have to have incorporated the tree into my life to make it something that I'm intending to use and derive value from over time. And I'd have to make it sort of known to everyone around or capable for everyone around to know that this is what I've done with this tree and that this tree therefore is mine and I count it as part of me. So imagine there's not even a government there yet. There's just this tree. Well, who the hell? It's, from all you can tell, it's just a tree. Now, if you're walking through a forest in an unowned area and you come upon a tree and there's a note tacked to the tree, property of Greg Salmieri, I come here every third Tuesday to water and weed around the tree, and I'm hoping to get apples from it or so forth, then it would be wrong of you to cut down this tree. There are plenty of other trees, and there's you've no claim to it in particular. I've made it known, put aside whether it's a right yet and what the government's involved in. I've made it publicly known that this tree is something I've put work into and that you would be taking it from me to do it. Whether that counts yet as a property right is something of another question. But absent that, you just come upon a tree, there's no way to know about it. And there's no way to know how you'd be interacting with me or if you'd be doing anything to or with me at all in your dealings with the tree. So part of what we need to have private property in a tree is some way to make its connection to the individual who owns it clear and objectively knowable to everybody. And part of what the role for the government is to do is to come up with a system of registering that. Deeds or an office, there are different ways that it could be done depending on the technology of the time, but some way to establish what belongs to whom and why. And so it's the basis of the right is that somebody put some productive work into making of the thing of value. But then for it to be a right in a social context, for it to be a full-fledged for it to really be property, there has to be implemented some way of people registering what they've made and making it such that everybody else could tell, and then to adjudicate the possible disputes that could arise about that. And then it's in that context that we have to deal with questions like, well, how many trees can you claim at once? And exactly how much work do you have to do to claim a bit of land, and what kind of, etc. So Ankar, do you want to comment on this or any thoughts about this?
Well, I think you've said the essence of what needs to be said. part of what's important, and we were maybe thinking of bringing this up in the next. There's a question about why didn't Rand spend more time with justifying the right of private property. I mean, I think she actually spends a fair amount of time. If you're looking at all of her writings on political, I mean, here's 2 articles that are all about property rights and thinking about them. But I think important in how you formulate it and how Ayn Rand formulates it, that it's not often formulated like this. It was, you put it in unowned land. So part of the question was particularly original appropriation or acquisition. There's a common way of thinking about that she rejects, I think, and you can see this even in people who are close to, or she's close to, in terms of the view about the nature and importance of private property. Someone like Locke, who treats that it's all owned in common. So there's some kind of common ownership of everything. And the question is, how do you get individual ownership of these things that are all given? And it's you get the kind of religious, it's given by God to everyone. So it's everyone holds some kind of claim to it in common. How do you get individual property rights? But her view is, no, it's everything starts off as unowned. There's no owner, and certainly no common ownership of everything by everyone. And then the question is, how do you get something that is unknown to become property? And then she has a view of of making use of it. And that's part of the issue of demarcating it. You're not justifying to the collective why you've taken their stuff, but you have to make it objective and clear, everyone. I've taken actions to make this part of my life, a part of the values that are enhancing my life, and I'm taking actions to make this clear to everybody. So you should now respect that this is what has happened and this is what I have done. And if you had done the same, I would respect that. I mean, that's I think her perspective here. So it's to view it as unowned is a distinctive feature. I mean, I don't think she's the only one who does it, but when you're looking at sort of some of the traditional theories and coming out of the Lockean tradition, this is a point of departure, and I think it's a significant point of departure.
Yeah, and Steve mentions the Lockean Proviso in the chat. I think we'll come to that be better to come to that a little bit later, but yeah, I do think how she'd react to the Lockean Proviso is related to this difference between her view and Locke's. I mean, it's worth thinking about the kinds of actions, the whole range of kinds of actions with land. So take this as the primary case, and Rand talks about land and talks about the Homestead Act, which she thought was the right way to deal with the vast amounts of unowned land in America, thought of incorrectly as publicly owned. But think about land and all the kinds of things that somebody might do that would make land valuable or would add new value to land. Whether the land was owned by somebody, you would do this to make it more valuable, a particular bit of land, or if it's unowned. Gordon in the chat mentioned someone who finds a gold nugget in a stream. And now he's been looking around, looking through all the different streams, trying to figure out where there's gold, right? And he finds a certain place where there is gold, and then he takes it to an office to register this claim, and now this bit of stream is his to work, I guess is it. I'm not sure exactly how gold claims work, but put aside how it works legally right now, there's a whole mountain with streams all over the place, and no one knows where to go. Once you find that this bit of this stream has a lot of gold that you can pan out of it, then you can just get a lot of gold from that bit of the stream. The work involved in getting that gold, though, isn't the work of panning that bit of the stream. It's primarily traipsing around the whole area and checking everywhere and finding which bit of a stream you can pan in, and that will have gold, right? So so that work, if you have a whole mountainous area with streams and such that's unowned, and someone traipses around through it and finds one bit and discovers that this bit is worth owning, in effect, because it has gold and worth working, that would be a way of something that is a kind of work that makes it of value and might make it such that he can own it. If you think about planting or harvesting or clearing land to plant something there, if you think about weeding around it, if you think about just intellectual work to identify which bits of land are useful for which things, which you find, oh, this land has this kind of mineral content. You put a lot of work into discovering where that is, right? These are all the different kinds of works that could go into land that wasn't valuable, but that could go into improving land. Some of it is something you actually do externally to the land, and now it's different than it was before, as when you clear the land. But some of it might be identifying from a whole continent the bits of land that there's a lot of intellectual work in doing that. So all of these are kinds of work that can be done to make land valuable. And there are new types of works like this that are, being discovered all the time as new technology is discovered, discovering that there's oil under a piece of land or whatever it might be, right? So what we need is a way to legally recognize when this kind of work has been done, a way to some standard by which this counts as having done enough work to claim the land. And then we need some entity to administer the task of figuring out who's done that or giving people a place where they could claim it. And so the way Rand says it is the proper task of the government to protect individual rights, and as part of it, to formulate the laws by which these rights are to be implemented and adjudicated. This is quoting from the Property Status of Airwaves, and continuing the quote. It is the government's responsibility to define the application of individual rights to a given sphere of activity, to define, i.e. to identify, not to create, invent, donate, or expropriate. The question of defining the application of property rights has arisen frequently in the wake of major scientific discoveries or invention, such as the questions of oil rights, vertical space rights, etc. In most cases, the American government was governed by the proper principle. It sought to protect all the individual rights involved, not to abrogate them. And so that's her claim on it. And so Diego's asking, responding to my earlier mention of an entity that registers private property, does it have to be managed directly or indirectly by the government? And I think, yes, that's part of the government's job, to create laws and standards, that is, articulate standards by which we can know, and everyone knows they're the same standards or whatever, that something is now owned by somebody. And that is part of the job of the government. Whether the government does it itself or standards are passed legislatively and there are various private bodies that can do it, but then it's adjudicated in court if there's a question about certification. Ultimately, that power has to be a governmental power.
Gordon has a question in the chat, which also came up in Facebook. How about something that was once property and then the owner abandons it? Do they lose the right to that property?
Yes, I think they do, but then part of what the government's job is to come up with objective standards of what counts as abandoned. And Augustina, we were talking a little bit before, you're a lawyer, so you know more about this probably than Ankar I do, about the doctrine of adverse possession in law.
Yes, the doctrine of adverse possession is basically allows someone to acquire property by possessing it for the statutory period of time, which varies from jurisdiction to jurisdiction. It has some requirements: open and notorious possession, actual and exclusive, if I'm remembering correctly, continuous, hostile to the interest of the owner, and for the and some jurisdictions require payment of property taxes. But the owner does not abandon the property. Mm-hmm. The person that wants to gain that property is hostile to the interest of the owner.
Mm-hmm. So what I was thinking, though, is if you start squatting on my property, right, and I call the police on you, whether or not the police succeed in getting you off or you come back and keep doing it or whatever, I've asserted my property interest against you, and you don't have an adverse possession claim against me unless enough time has passed. So isn't it that the adverse possession claim applies if you started squatting on my property, 10 years ago or some amount of time ago, publicly? I had every opportunity to know you were there, you weren't hiding it, but I've waited, 25 years to call the police. And now I'm saying she's been on my property all this time or whatever. I've, in effect, it's not what we normally think of as abandonment, but I've in effect abandoned the property or my claim to be able to evict you from it because I had an obligation in effect to exercise it prior to now. My having not done that is my not taking the actions to keep the property, so to speak, my not treating it as a value, and you therefore have come to adversely possess it, and now you count as either owning it or having an easement to it, maybe, to do what you're doing on it. Is that how it works in law? I mean, that's how I have thought about it.
Yes, that's how it works. You don't have an easement. You actually have a right to be the owner of the property.
And it might be that there are other kinds of rights besides ownership rights that can be acquired in that way that are like if I cross my property, your property with my hunt, every year or whatever, and have done so for 30 years and wave to you as I do it or whatever, and you know that I'm there, whether it's this way in law now or not, you could imagine my adversely acquiring the right to do that by having never been objected, but I'm openly doing it in a way that's violating the claim you have to it. I don't know, and that might vary from jurisdiction also. But yeah, so this is on the issue of abandonment. And then there was just normal ways of abandoning something.
Yeah.
I mean, Adam, sorry, Onkar, go ahead.
Take a very simple way of abandoning things. It's you put something out for the trash and somebody takes it. And so it's you put it as you're discarding it, you no longer want it, and it is the other person takes it. It's not exactly a trade. It's that you've discarded it as property and he's picking it up. And there's, I think, more complex cases than that. But again, it's really important that this be defined and codified. So it's not, oh, this guy stole my stuff. It's if I put something in my driveway and someone comes along, oh, I thought it was trash. And so it has to be that for all these things have to be very clear. And it's part of the demarcation role of the government.
So Rand lists the Homestead Act as an example of this having been done properly with land. There are a lot of questions that you think about with the Homestead Act, like there's only a certain size of land you can claim, I forget what it was, via the Homestead Act at a time. To claim it, you had to be on it for a certain amount of time. I forget what amount of time it was.
But what she specifies is the government offered a 160-acre farm to any adult citizen who would settle on it and cultivate it for 5 years.
Mm-hmm. Okay, sorry, I'd forgotten that it's actually listed in the article. So why those numbers? Why that size of farm? Why 5 years? Can you do like 10 of them at once? Can you like homestead 2 properties next to each other and then you can get twice that distance? But, presumably not. Otherwise, there'd be no point in having the size restriction on it. So where do those numbers come from? Why? Any thoughts on this from the chat? Is that like in human nature that it's precisely that much? And it works out to a round number in the British measurement system. If we were metric, it would be totally, we'd be wrong because reality goes by the British rule system. And 5 years, that's how long it takes to mingle your labor with something, or why is it? Paul says it's all subjective.
Yeah. With the smiley face, though.
Yeah. Diego's asking where he could find the Facebook. We should put the link in.
I'll copy the link.
Thanks. So, I mean, I think pretty clearly it didn't have to be 5 years and this many acres, right? What needs to happen is that there's some number defined in law so that everybody knows what it is. But it also couldn't be any number, right? So I don't think it could be like the first guy to plant a seed in Montana owns Montana. It took him 5 minutes to do. He's not done anything to most of Montana. He's got no way to cultivate all of Montana. Most of Montana is not of value to him except as, maybe someday it will be. He's not interacting with the whole of Montana because he can't with something that large. And he hasn't, right? So it can't be that, but it also couldn't be that you can, only homestead, an eighth of an acre, an apartment building size bit of land in the middle of basically wilderness, which wouldn't be of any use to anybody, and there'd be no way to, you could have, if some block in the middle of Brooklyn was unowned, you could, presumably have a system where you could homestead, house-sized portions of it. But, in a bit of land that is, the ways to work it and use it are such that they're not useful without a pretty large space, and you need a space that's comparable to the kind of uses that it could be put to. Gordon's saying the government uses the aliquot part system to fractionalize properties along townships and ranges. 160 acres was determined to be what a person could prove up on in 5 years. I don't know exactly what that means, prove up on.
Maybe improve, I don't know. And I think part of the issue in terms of thinking of it, of the principles that go into it, you can't forget about what the purpose of rights is, and that the government, its goal, a government is normative, so its goal is to enable people to exercise their rights, but the rights are there so people can pursue happiness, and to do that, they need to be able to think and they need to be able to produce, as the two crucial things. So some of it, I think, is dependent on the state of technology, and so that if it was in a more modern context, you could imagine the size of the acreage, when you've got industrial tractors and industrial farm, it could be bigger than that. But a person with farm animals and so on, he can't actually use productively this whole swath of land, even if the animal walks across it all. And for a lot of these things in defining airspace right, oil rights, it's the needs of the producers. It's both recognizing they created value, and the whole goal is to continue to create value. And how is that possible? And what system of rights do we need to make that possible for everyone?
And if there's it's not any value that could conceivably someday be extracted from the thing by some means, God knows what, that's relevant. It's what things they could actually accomplish and could have understood themselves as having been in the process of creating while they were doing it, and they actually did create it. So you imagine, in one sense, you can think of there wasn't a government and there was a person doing this, and what could his goals have been, and what could he have seen himself as having created and then succeeded as creating. But it really can't happen without a government, because without a government, you couldn't set out to clear a large area of farm and expect to recoup on it. You can't really live in society without a government, not in any kind of decent way. So you have to imagine what kind of set of rules of acquiring things, given human beings' abilities and the present understanding of nature, could people make it a goal of theirs to make this thing a useful part of my life over what period of time, and then demonstrate that they've done that. And what kinds of areas of land or what kinds of property and how long it takes and by what actions is going to change as not just the technology of tractors and so forth develops, but the kinds of uses to which land can be develops, and new ones are discovered and so forth. Gordon's saying that prove up on means staking the boundaries, putting in a garbage pit, putting in so the various things involved in working the land. Very well, thanks, Gordon. It's not a phrase I was familiar with. All right, so just a thought on when people talk about intellectual property, or these ideas like property status and airwaves, or what's the property status of air rights, or what do you mean you think there's property in the environment or in the atmosphere or this or that. They tend to, so Rand had this idea that people often treat low-level concepts, not that far from the perceptual level concepts, as though they were percepts. They were just immediately, directly grasped and couldn't be any other way. And they treat any concept above that as sort of hot air or not valid. And it's because, what you need to do to understand the higher level concepts and their basis is to first recognize the kind of work, intellectual work and objectivity that went into the lower level concepts that you're taking for granted. And then see that that same kind of work applies beyond that realm. And a lot of people, it seems to me, take the concept of property in land and in chattels, for lack of a better word, like objects you can carry around with you and so forth, take that concept for granted as though it were always here, as though everybody always understood what it was and how you get it. And that's just not true. I mean, the idea that an individual can own a piece of land and what it is to own a piece of land is a relatively recent idea. I don't know exactly when. It's not clear that even the feudal system has it. Maybe it's just as new as the 18th century, late 18th century, but it's certainly not every society has had it forever. Maybe it's been in different societies at different times for periods like the Greeks had it. But certainly nomad societies, I don't think they have the idea that if you stake your tent on a bit of land for a while, you permanently own it and you can come back here next year and that bit of land was yours. It doesn't seem to have that. Maybe the whole tribe owns the land over which they roam, they might think, but then how is that different from it's their territory as though they're the government of it? I mean, to have the concept of property, you have to have the idea of, it's not that I govern this thing like I'm the sovereign of it. It's governed in one way, but then part of that good governance of it is that different bits of it are owned by different people. And then it's not the case that each bit of land is some self-contained item that has no impact on other items. Like you get these environmentalist arguments against property. Well, you can't really have private property rights and have them be absolute, because what you do on your property affects the property next to you and somebody on the other side of the world and so forth. So everything's all interconnected. Yeah, everything's all interconnected. That's why we need property rights. We have one earth that extends in all directions and so forth. And if I'm going to start working some plot of it, right, we need to figure out, given the fact that it's contiguous with the rest of the surface of the earth and the air blows over it and so forth, how are we going to separate it out? And that separating of it out so that this bit of it is mine in virtue of the fact that I did something that makes this bit of it valuable, right, is a process. We have to identify, well, how can we distinguish the bit that I've worked out from the other bits that I've made valuable from the other bits, given that they're all connected, given that animals graze over all of them? Well, do I have the right to hunt them? What if they're on their way to yours? And who has hunting rights here and so forth? All of these things are achievements human beings have to think about. There's a doctrine of the right to capture in law to do with hunting rights, and then water rights got built based on that and so forth. And all of this is didn't have to be this way in the sense that it might be the right way for it to be, or there might be options as to what the right way to be, but it's not like we all automatically knew what was whose because it was given by God, or reality just wrote itself on our mind until there were radio waves or oil. And then suddenly we're up in the air. How the hell do you know who owns something, right? It was a real achievement to figure out land property and who gets to hunt where and so forth, and to figure out a way to adjudicate those issues such that the people who created values got to consume the values they created and to control the values they created. That's the accomplishment. And the question is, how do you extend that to the cases where it's not done already and we don't already know how to do it? Okay, my camera is focusing strangely. Let me change this.
Yeah, should we see any questions on what we're talking about, what we've talked about so far? And then we're going to talk a little bit more about the Lockean Proviso and then go to some of the more specifics about.
Yeah, and just the contrast with a couple of other figures. I don't know how much more we want to say with a little bit on a few other figures people asked about before. Do you want to say anything about the question Mark's raised in the Q&A, Ankar?
Where's that? can you please compare and contrast how a proper government would manage unclaimed property yet to be properly claimed as private, with the way it currently oversees public property? I mean, I don't think there's a concept of public property in the sense meant here. So if it's so currently overseas, so if you think of the U.S. government, I mean, I think, Greg, you talked a bit about this in one of the previous sessions last week, I forget which one, about so it owning huge swaths of forests and all kinds of land, I mean, a lot in the West, that this is the proper view is that it would be unowned until private individuals take the kinds of steps, part of which we will be talking about, but I think in a modern context, they can include more than just homesteading for setting up a sort of self-sustaining farm and things like that. There would be all kinds of things that can be done with this land. But it would be treated as unowned, the way that she puts it, the way that Ayn Rand puts it in the article. I think she even italicizes this. The government's the custodian of these unowned things, and what its basic purpose is there is to, in an orderly fashion, make it possible for people to own these things when they view it as, now it's in my interest to try to take some of this unowned things and convert it into property, that I'm going to set out to do this because I think I can enhance my life and create value by doing that. And that its whole role is to make that possible and as easy as possible, so that it would be encouraging this to happen, not putting every obstacle, even though once in a while some of this land does get into private hands, but it's like, that's like a law, it's considered a loss, whereas proper government would be, yeah, we're pro-development, we want people to take this unowned stuff and create values with it, and we make it possible and as easy as possible for you to do that.
So Steve's asking, some left anarchists like George and Tucker allow for private property as long as you're literally using something, and reject what they call absentee ownership. What assumptions underlying these theories differ from Rand? So on this view, I own the shirt on my back because it's on my back, and maybe the shirt's in the drawers upstairs because I'm still in the house, but if I go on vacation, I don't own the home anymore. Or more likely, they think you can own land, absentee, that's owned in common. First, I should say, I don't really buy the concept left anarchist as opposed to right anarchist, because I don't think left and right mean that much to begin with. And so I just call them anarchists. But Ankar, any thoughts on these ideas of George and Tucker, that you can have private property if you're using it literally, but no absentee ownership? And what assumptions they have that are different from Rand's?
I mean, I think one of her perspectives would be this is enormously concrete bound, or it's a perceptual level mentality, I think she would think. And it relates to some of what you were saying, Greg, earlier about taking the sort of more perceptually available instances of property, but airways, how could that be? This is like 4 rungs lower than that, in that, oh yeah, so I can I'm drinking this glass of water, so it's this. But if I put it down and leave it there, or if I store things in case of an emergency and they're 2 years there not being used, like, how's that property? Because isn't it just like other unowned things? Part of what rights make possible, and property rights in particular, but everything that goes with it, the possibility of trade, of contracts, of long-term contracts, part of what it makes possible in thinking of the issue of production is, and Rand often stresses this, is production long range across time with and she'll put it, the more productive and ambitious the person, the longer his range. And companies and real innovators in business think over spans of 20, 50, 100 years of what they're doing. And that property and property rights, and the recognition that this is part of producing, and therefore we have to protect it within a system of property rights and contracts, and you can contract over this range of time, all that would be rendered impossible if all it is the immediate moment, what you're using, and the moment you set it down or leave it for an hour or a week, or that's it. All of these, like the massive, what we think of as industrial capitalism or the modern world, would all be impossible.
And not just the modern world. I mean, agrarian, the agrarian world, hunter-gatherers can live like this, not civilized people in the literal sense of civilized, and or even pre-civilized, because the farm's not a city yet. What assumptions underlying these theory differ from Rand's? Well, the view Rand has that they don't is that land or anything to be of value requires the application of the mind. And it requires its incorporation into one's life, and that lives are lived over time. So this is the same point about the range in space and range in time. But if all you think you do, if your understanding of what your action is and what it is for you to be living is, well, my heart's beating, it was beating a minute ago, and here's where my hand is, and my life is just, like what I can reach and touch, and I'm not engaged in any processes that are outside of the range of my immediate vision and the immediate moment, then I count as literally using only the things that you can see in my hands. But I'm literally using all kinds of things. I'm in the bottom floor of a several-story building. I own the first 2 floors of them, and I'm using all that. And I'm using my car that's elsewhere. I mean, all of these things I'm literally using now. I'm not in them right now or moving them around right now, but I'm using them. I have planned for them. They're playing roles in my life. There's nothing figurative about the fact that I'm, if I bought something as a collector's item and I'm waiting for it to go up in value before I sell it, that I'm using it. It's appreciating right now, and that appreciating is something I'm doing with it. I have something cooking in the oven upstairs. I'm using the oven to cook it right now, even though I'm downstairs and away from the oven. These are not figurative uses. They're literal uses. What they're not is they're non-perceptual level uses. They're uses that you have to think and think long range to come up with and use things in this way, and then to appreciate that other people are doing this. And so, in effect, this Tucker and George perspective is, the perspective a chimpanzee might have on what it's like to use something and then to own it. And so what assumptions do these theories have that differ from Rand's? They assume that human beings don't have reason and don't think and live long range. And she assumes that they do because, well, they do, or they can. I don't know. I don't know what some of these guys are up to. But. Okay, Gordon's posted some interesting information about the native, some of the details of homesteading. But I think we can. Thanks, Gordon, for posting that. It's edifying. I think we can leave it aside for right now to move on. Can we? Ankar, do you want to talk a little bit about how Rand's production-based theory, Steve asks, Steve's got a lot of good questions this week, how Rand's production-based theory is it an alternative to Locke's labor-based theory of value? Is it a kind of extension or development of it? How do you see those two as related? And if you want to talk about Lockean Proviso.
Yeah, I personally think of it as an extension and development, but that also includes some sort of precluding of error, or at least possible errors in doing that. So I think it's debatable to the extent Locke makes the error, but in how some of his formulations and terminology was used, I think is erroneous, and I think Rand would think it's erroneous. So you get one of the metaphors you get is in this labor theory. So I don't think it's the Marxian labor theory of value, but you mix your labor with the thing, and it's part of how it becomes property. And then you can look like, how much was it? It's 99% contributed before, and you contribute a little bit of labor, but it's still mixed and it becomes property. And there is a point to the metaphor of mixing your labor with the thing, I think. And it is, I think he's using labor in a broad sense. It's not just physical labor. It's purposeful human labor directed at the creation of values that advance a person's life, his health. In the founding fathers' terms, his pursuit of happiness. And that is what Locke is focused on, even when it's the issue of carving out from the common, that is everything held in common. Part of his argument is that in doing that, what they're doing is enhancing if we take land, they're enhancing the land that it now can be farmed or you can raise animals on it and so on. And so there's a perspective from which you can think that they're actually increasing, not decreasing the amount of land that there is, that is of productive land that actually supports human values and human life. So he doesn't have this perspective, I think, that we've got a limited number of things, and when someone takes out of the commons, everyone is worse off. He actually has a perspective, I think, that this is how civilization advances, and in that sense, everyone is better off. That people take these things that are held in common. Now, as we've talked about, Ayn Rand rejects that they're held in common, they're unowned. But in his term, they're held in common and converts them to private property. That's an enhancement. And that is a very important point, I think. And the mixing of it, when you get that when you make something, that you feel that it's part of you, and that you have a relationship. I mean, just think of people around the house that they've built their the deck in the backyard, and that they feel a pride and an ownership in it, because like I've done this and brought this into, and that you give a metaphor, well, you've mixed yourself with this thing, and you mix that, I think, captures a point about it. But if it's now taken as a literal formulation, not a metaphor capturing something important that you would, if you were putting in literal terms, would put in a different way, then I think it starts to go awry, and you can get all kinds of problems with it. And it's for various things that are owned. There's the question of like, how exactly is your labor mixed in this thing, and how are we to think about that? And then I think followers who are using this, it becomes, I think in Rand's terms, it becomes a kind of intrinsic approach to property. And one other thing I'll say, and I think in followers, it becomes a way to try to bypass moral issues. That it is, and this is the intrinsic sort of it is, well, you've mixed your labor with it, so it's yours now, without any focus on the issue of, was there actual production going on and value creation that the individual is now trying to get possession of and have it protected and so on. It's just, no, all we have to do is find, oh, there's a little bit of mixture of your labor, and so that's it. And we escape all the normative issues. And you can't do that. That the rights are normative.
Do you want to, I noticed Steve in the chat is referencing Nozick's radioactive tomato juice argument. Is that in Anarchy State and Utopia? I'm not remembering that metaphor.
Me neither.
Right? I take it the idea that if you mix something radioactive into the tomato juice, the whole of the juice that got it mixed in it is now radioactive.
Yeah, I mean, he certainly has examples like that. I don't remember that particular one, but the ones are given like this. Like if you do something and a drop in the ocean, and is it all mixed with, and do you own the whole ocean? And so, and this is the intrinsicist conception of it. It's that there's this thing, labor, and it's treated sort of as a physical thing that is mixed in, and now is it 1 part per billion or 1 part per trillion? And is 1 part per trillion, does that still count? So it's very physical and materialistic, and that's the non-normative aspect of it. And I don't think that's the right way
to think of it that way. The other element of the mixing idea is that the value of if you have a mixing kind of metaphor, the value of the land is now going to be in part due to what you contributed to it, and in part due to what it had before, absent anyone's contributions to it. So that and then the question is, what are the proportions? But I think that's a category error. They're not the same types of things. Nothing is of any value absent somebody coming up with uses for it. So it's not that 90% or 157%, it's 0% of the value is in the land, and 100% of it comes from your interaction with the land, or whatever it is. And the land itself has no value. What it has is the potential to become valuable. And this gets to the kind of Lockean Proviso idea, because there's the idea that when you create a value, or you create more value by producing, making some land into a farm that was just wilderness before, when you create some value, you've also now appropriated to yourself or taken away from other people, or from the potentiality of other people to acquire the land, which had some value already in itself. But really, at least as I understand it, and I think how Rand thinks about it, the land has no value in itself. All it has is the potential to be acted on in ways that would make it valuable. But that itself is not of any particular value. And when you make the land a value and it becomes property to you, it's true, once you do that, the land doesn't remain as an unowned item out of which someone else might forge a value. But it doesn't mean that you've thereby diminished the stock of potential value out there in the world, leaving fewer opportunities for future human beings to create values. Because you might have diminished the stock of unowned land in the world, out of which somebody could, then produce real estate as a value. But there's an infinite amount of things that could be made valuable. Once we understand that the basis of property is not, it's not just land and then all the land gets owned and, oh, well, now there's nothing more to own. You can come up with ideas, you can discover minerals and then become mineral rights there. You can get to the moon and get rights in that. The whole universe and all the different patentable things and whatever that could be discovered are all potential values. And the more value you create, the more you put yourself and other people in a position to create more of these other potential values. So there's no, the Lockean Proviso, which has been mentioned, is the idea that when you appropriate something to yourself, you have to leave it enough and as good for others, right? The idea is, eventually you might run out. But there's no running out, because there's nothing special about the category of land. It's what the thing is before you own it is just a potential for, if someone figures out a way to make this thing valuable, then he can own it. That's what there is in nature, and there's an infinite amount of that. And if the particular land on a continent runs out, well, there are plenty of other things to make values of.
I think this is it. To get, I think just Locke is not, he hasn't thought these through, and he doesn't have a fully integrated position. But I think it's relevant here to think of that he thinks of it as it's commonly owned. So it's being used by everyone and then is being used by someone. But some of his examples are clearly, no, it's totally useless until someone comes along, and it's clear all the value comes from that. And he doesn't distinguish those two kinds of cases, and it's part of it. It's this whole religious framework that it's all been given and to man or mankind, and it's being used, not it's unowned, and there's no value to it until someone comes along.
One more issue maybe we should say a word about by way of differentiating Rand's views from others before we go into specifically the airwaves and then patents. And that's the idea which you find in Hume, and Steve in an earlier post mentioned it being in Hoppe, and Daniel mentions it in being in some current libertarians having it. The idea that the source of property rights lies in scarcity. Ankur, do you want to say anything about that?
I could say a little bit. It's, I think part of the motivation for it is that it's not wrong, but it's not the primary from Rand's perspective. So this is what the point of disagreement is about. It's thought of and I think rights in general, not just property rights, are often thought of from the following perspective: that they're a way of either ending or diminishing conflict among individuals. And the scarcity is, well, these things are scarce, not everybody can get it, they're going to fight over it. So, and that's not good. And there won't be any real use to this. So you've got to, and it's sort of, we need a system where it's better for everyone. There's less conflict. People can use it. There's not all fighting over it, but it's the fighting over it, and that's not a good outcome or result. So we need something to somehow preclude that. And the perspective I think that you get with Rand is it's the emphasis on the value creation and being able to then reap the rewards of the creation that you've brought about. And that's certainly in regard to property rights, but in general, it's this idea of right, it's towards a positive goal, and it's the individual trying to live his life, and this is what he needs to be able to do, and this is what we need to protect. But in regard to property, then, that you can conflict when and Greg, you've often been emphasizing that it's, yeah, we each have our individual life, but we interact in all kinds of ways. It needs to be clear and demarcated. You don't start off as demarcated about how do your actions, that they're yours and that's going to be respected and understood, and including then what you produce and that it's regarded as yours and you have control over it. So it's the carving out of that's important in regard to rights. And then one aspect of it in regard to property rights, and for instance, in the property status of airwaves, she brings this kind of thing up. Just as so quoting, but this is on the third paragraph. Just as two trains cannot travel on the same section of track at the same time, so two broadcasts cannot use the same frequency at the same time in the same area without jamming each other. So there is, if you don't do this properly, if you don't demarcate property rights well, there will be conflicts and so on, and you will interfere with each other. And that kind of perspective that the scarcity argument is bringing up, I think, is real, but it's a very secondary thing for Rand. And the primary is how to protect value creation and the pursuit of life, and it's not how to avoid conflicts.
Yeah, you can think of the conflicts are a symptom that this hasn't been done properly and needs to be done, that the defining of the right needs to be done because it hasn't been done properly, and therefore we're running into conflict. But it's not the reason why it needs to happen in the first place. And I think the ultimate idea of the right thing that's right in the idea of scarcity is that the property is what's been produced, and in a certain sense, the only thing that's scarce is our producing. Well, that's the primary thing that's scarce anyway. And even when we think about the materials out of which we produce, there are no natural resources that are just useful. Things are only natural resources relative to processes someone's come up with to make use of them. And if there aren't enough we're running out of one thing, well, what we need to do is make something else valuable by figuring out a way to make that other thing and input into our processes. And, Rand talks about in Atlas Shrugged and elsewhere, the idea that the oil was just primitive goo underneath the earth until somebody came up with a way to use it to make machines. And it will be that again if you lose the knowledge of how to make machines of it. And, silicon is just sand, and which is useless until you know how to make chips out of it. And likewise for a million other things that we don't yet know how to make use of. So what's scarce isn't the molecules or the space in the universe or something, but the ways to derive value from it. And I think that what we're saying now, it really addresses what Steve's saying about socialists like Cohen, who say that you can't just assume it's okay to appropriate unowned property because it limits others' potential to own. So you have to have a special argument for why you can do that. And we have to find some way to limit it. And the answer is, you're creating when you come to own something. And your creating does not take away from the other people or leave them worse off. So that's not an argument that you can do it. It's a rejection of the premises that there's something wrong with doing it. Okay, so let's move specifically to the issue of the airwaves now. And Ankar, in talking about the jamming, brought up the symptom that showed us that something needed to be done here. People had developed this new technology of broadcasting, and different people were broadcasting and using it in different ways. And we were in a situation where one person's broadcast was jamming another, and there was clearly something needed to be done about this. Something had gone wrong. And what was actually done was there was a communication act by which the what ultimately became the FCC was founded. And this amounted, in Rand's view, to nationalizing the airwaves. So the FCC issues broadcast licenses to particular stations, whether they're radio stations or now television stations, which, you know, don't own the airwaves. The government owns them, but they're licensed to broadcast on them. And this is presented as the only alternative to the situation there was before, where it was just a mess of people broadcasting all over the place and jamming one another. And her view is that what we had before wasn't capitalism or freedom or a free market, but the thing that Rand views as the opposite of that, or one form of the opposite of that, namely anarchy. And what was needed was the institution of law to define rights in the area. But what we got instead was the government taking over the area, stealing it, nationalizing it, and then putting strict controls over how it's used with nobody having any rights. So there are two, it's normally looked at as anarchy versus regulation, or freedom versus regulation. Her view is there's the right alternative is lawful protection of rights, legality, versus anarchy or controls on the other, as the two wrong things. And so the proper solution would be to make these things ought to be private, and the proper way to get them to be private, or to recognize them as private originally, is to have something like a Homestead Act, or that same kind of principle. The first people who were stably using a frequency for some productive purpose, like the first guy to establish a station on a frequency, for example, would therefore have a right to that frequency in perpetuity, unless he was adversely possessed or whatever, presumably. Now she thinks, given that it's too late to do that and nobody knows who would have owned it anyway, they still need to be made private property, but the way to do it is to auction them off to the highest bidder, basically. So any thoughts or questions specifically on this proposal regarding the airwaves? Or view of understanding of the history of the airwaves and why they should be private?
I think, again, it's just worth emphasizing, and she emphasizes this often in these kinds of discussions about property rights, but more broadly about societal conditions and organization, that it's the indispensable need for production that forms the context for how you're defining these. So it's not, in terms of defining the airwaves, it would again be relevant that the technology and we're able to broadcast in this kind of band, and this is what we're using in order to whatever entertainment programs or news programs to people in this geographical area. And it's okay, so that's what you're doing. This is what you're creating. How do we create a system that protects the values and enables you to secure the values you're setting out to do? And if you're talking about, with advances of technology, the spectrum can be divided in different ways. And so that's all the government will be thinking about, because what it's trying to do is enable production. But that means enable individual producers to produce. if that's what they're choosing to do.
Go ahead.
I was just going to say, it helps with thinking about the arbitrariness of it, like why this much and why these frequencies, you have to get that the government has to be looking at the actual activity going on and what's actual value creation or the value being created.
That it's showing that the selection of the numbers selected isn't arbitrary. There are reasons, and the reasons are that we're observing the kinds of value-creating acts that are taking place, the nature of those acts, and we're using those to figure out what protections need to be put in place to enable people to perform those acts and reap the fruits of having done so. So we asked a question about what broader issues or principles we discussed in previous sessions or came up in previous readings are at work here, and there are a few of them that we can take a look at before we go to the IP intellectual property issue. Daniel mentioned the idea of the public interest and public property. Well, actually, what Daniel mentioned specifically is the idea of the tribal premise that Rand discussed in, he says, man's rights, but also we talked about it more last week in connection with what is capitalism, right? Which he talks a lot about it. He talked about the tribal premise being at the core of Herbert Hoover's radio licensing laws. That is, Hoover was the Secretary of Commerce, I think it was, or he was a cabinet member at the time. It was Calvin Coolidge, thought of as a great defender of laissez-faire, incidentally, who was the president at the time they nationalized the radio waves. And Hoover was one of his cabinet secretaries. And Rand quotes a speech of his arguing that we need to do this. And he says that's on the tribal premise. I think that's very much right. It also uses, and the subsequent discussions of this use the concept of the public interest and public property, which are these tribal premise concepts that Rand identifies as invalid concepts and non-objective. Another principle that I saw here, which no one mentioned, is Rand's, or I don't think anyone mentioned it, is Rand's view that we saw back in Man's Rights, that private property is the means of implementing other rights, all of your other rights. And here in the Property Status of Airwaves article, we really see this with the right to free speech. So she, at this time in the 60s, was very concerned with the government censorship, and particularly censorship being implemented by the FCC. You'll notice she mentions Mr. Minow and Mr. Harris. Minow is Newton M. Minow, incidentally the guy for whom the SS Minnow on Gilligan's Island was named. And it was named after him because he gave a speech criticizing television for being a vast wasteland. He was the first of Kennedy's FCC directors. And he gave this speech about how awful television is, that it's got all this entertainment programming and not enough public interest programming, and basically, you know, threatened that he was going to revoke licenses unless they started having the kind of programming that he wanted. And happily, there was a pretty significant backlash to him. Rand was really up in arms about him, but she wasn't the only one who thought he was a controversial figure. And she wrote a lot of articles about that the FCC basically has the power to become a censoring organization, has a near totalitarian power already because there's this arbitrary power to regulate in the public interest. Why does it have it? Well, because the airwaves were nationalized rather than being treated as private property as they ought to have been. Now people need his permission to speak, and there's a whole series of articles on censorship from her that are centered around this threat from the FCC. And this article, The Property Status of Airwaves, is tracing it back to why does this guy have this unaccountable power? Well, because something that should have been private property and should by right be private property was seized by the government, and now we lack the property protections that would be enabling us to speak freely. And
one of the things that I noticed on this reading that I didn't remember is you can sometimes read her warnings about the FCC and antitrust, which were two of the big things that she was concerned with, which is if we allow this to continue, things will get really bad. But part of the reason she's up in arms about them is she thinks they're already really bad and they're going to get worse, still worse, but it's not some distant future. And here's the paragraph from the property status of airwaves. All media of communication influence one another. It is impossible to compute the extent to which the gray, docile, fear-ridden, appeasement-minded mediocrity of so powerful a medium as television has contributed to the demoralization of our culture. Close quote. And that's a pretty strong statement about it. And it's part of why she's so concerned about this, I think.
And if you read her early 60s articles on censorship, we'll talk about some of this material next week, although more the 70s material. But she thinks we're in a really horrible state. And these are not slippery slope arguments like this is okay, but it'll get really bad. Slippery slopes are only a problem to slip down because the whole thing is bad. There's something bad now that's happening if it's a right kind of argument like this, and then it might get worse, or it will get worse. Dave asked, how is the ability of the FCC to censor licenses and so forth, to censor ideas by refusing to renew certain licenses, been affected by the internet? Well, it's been decimated. I mean, worse, it's been largely circumvented by the internet. The internet created a great flourishing of new free speech. It encouraged tremendously the great diversity of ideas we have now versus what we had in the 70s or 80s. And that's why everybody on the right and left practically wants to destroy it, which is why we have an orchestrated campaign against Google and Facebook and Twitter by anti-right freedom haters like Ted Cruz and Dennis Prager on the right, and by tons of people on the left, like the New York Times with an article today about criticizing Facebook and Twitter and so forth for allowing anti-Semitic and other, granted, awful speech on their platforms. For this very same public interest, not valuing freedom reasons, that the airwaves were attacked and destroyed as a medium of free communications. The internet is now in the sights of all the people with anti-freedom ideologies, which exist across the traditional political spectrum, that is, people who think of themselves as right-wing and left-wing. And I see that as the most pressing political issue right now. I don't know how you count it, Ankar, compared to the other.
Yeah, I mean, I think free speech in general, and this is one of the most ominous, and certainly domestically the most ominous threat. And particularly because it has such support from camps that people think of as different. Yeah.
Paul Turney mentions Trump as well, and that is as well as somebody who wants to censor. But he's a really interesting example here, because without Twitter, there wouldn't be a Trump presidency, right? So it's an example of, and people who've heard me in the past know I'm no fan of him, right? But the fact that an outsider like Trump, and even before that, an outsider like Obama, who was relatively an outsider compared to the Democratic machine that was backing Clinton, right? Both of our last two presidents are people who by conventional wisdom would not have gotten to where they got, right? And did so because the internet and the kind of freedom that's made possible by the internet of expression allowed ways for new, not ideas, because neither of these people really have ideas, but new positions and new approaches to get a large audience. And one of the reasons why our political process has become a lot less predictable is because a lot more people are able to speak to more people in new, unconventional ways because of the internet. And now the people who have managed to use that to get themselves into power temporarily, which includes some of the Tea Party people like Cruz and so forth, are now trying to use the power they got in via this to destroy it and not let other people come up after them. Augustina, you had a question that you were raising with me beforehand about this article.
Yes, it's I think I understand what Rand is trying to say in this paragraph, but I'm not sure it would be very clear to everyone. She says, the fact that the number of available frequencies was limited would have served not to entrench the original owners, but to threaten their hold if they did not make the best economic use of their property, which is what free competition does to every other type of property. And then the question is basically, what if a person doesn't make a good or any use of the property? Why would he lose it on a free market? And this could be, I think, interpreted. There are some theories that say that government should be allowed to take property that is not being productively used or used in a way that the government regards as good or used at all, and they have the right to take it and give it to someone else that will make a good use of it.
So there are really two issues here. One, is Rand making an economic claim that on a free market, as we'd expect her to understand a free market from what she's written on it that we've read elsewhere, is she saying that just as a matter of economics, the market will function in such a manner that a person won't be able to keep it without using it? Or is she saying that that's not the case, but when somebody does keep something without making any productive use of it, that's either a sign of the market's not being free or a way in which it's unfree, and therefore the government needs to interfere to create the kind of conditions of freedom where these things get taken away from someone? So I'm confident she's saying the first of those things. There's a point about the nature of markets whereby she's saying somebody won't be able to just hold on to a broadcast frequency indefinitely without making any use of it or any other valuable item. And this gets into the material we were talking about the objectivity of the market last time, and about how Rand understands a market economy. So Ankar, do you want to comment at all on that?
Well, I think it's worth then quoting a little bit more of what she writes here, because I think it's for sure she's talking about the operations of a market. And I think the way to think about it is not of some one particular piece of property, but of can this be a general phenomenon? And so it's to continue a little more of the quote. With a limited supply and a growing demand, competition would have driven the market value of a radio and later TV station so high that only the most competent men could have afforded to buy it or to keep it. A man unable to make a profit could not have long afforded to waste so valuable a property. And if you think of the kind of context, it's gaining in value. He's not reaping any of this value. There's all kinds of pressure. Just it's gaining in value. So it's okay, if I sell it, I can make $1 million. Now I can make $2 million. It's at some point, even the worst of people will, okay, I'm going to cash in on this. If it's owned by a family trust, it's the better people will be pushing. It's like, we should liquidate this and sell it, and we're not making any use of it, but we can get some value from it. And it's precisely because it's so valuable, and the market's communicating to individuals. Look, this is so valuable, and there's people here who can make a tremendous use of this. All the pressure and forces is, if I'm not making the best use I can do of it, then it's to sell it to someone who will go on and make even greater fortune with this. And yes, you can imagine some completely irrational person who no, I'm not going to sell at all. I'm going to take this to my grave and so on. But all the pressure in the market is for that not to happen. And it doesn't happen on an economy-wide scale, because it means that you've got a big swath of the population that is now uninterested in their own interests and the pursuit of values, and that kind of degradation can happen. But the source isn't the market; it's extra market things, I think.
Okay, so shall we move on to the topic of intellectual property? Okay, so the big headings here, I think, that we want to hit on is why Rand regards it as property, how she regards it as different from other types of property, physical property, how these differences lead to the limits in duration. I think those are the kind of big headlines there. So why is it property, and how does it relate to other types of property? Ankar, do you want to start us off on this, or shall I?
Go ahead.
Well, if we look at the beginning of the article, right? I'll just read I'll read the first two paragraphs, because I think they're really crucial to getting how she comes at this. Patents and copyrights are the legal implementation of the base of all property rights, man's right to the product of his mind. Coming back into my own voice now. Okay, we know why she thinks Rand's right to the product of his mind are the base of all property rights. Now, patents and copyrights are the legal implementation of this kind of fundamental feature that's at work in another way in all property rights. Okay, continuing to the next paragraph. Every type of productive work involves a combination of mental and physical effort, of thought and of physical action to translate that thought into a material form. The proportion of these two elements varies in different types of work. At the lowest end of the scale, the mental effort required to perform unskilled manual labor is minimal. At the other end, what the patent and copyright laws acknowledge is the paramount role of mental effort in the production of material values. These laws protect the mind's contribution in its purest form, the origination of an idea. The subject of patents and copyrights is intellectual property. And then she goes on to say that it has to be given a material form to be protected by property rights, and so forth. But what's going on here? Well, you might think, look, there are just different things that can be owned, and an idea can be owned just as anything else can be owned. And I think, I forget who is it, somebody mentioned Spooner, it might have been Steve again, mentioned Spooner's view of wealth and how this applied to his view of intellectual property. And I don't know Spooner very well, but it's seeming like Spooner's there are things that are valuable. If something's valuable, it can be owned, and ideas can be valuable, just like land can and chattels can, so they can be owned. But I don't think that's how she's thinking about it, right? The whole idea of property rights, if we go back to even how they're discussed in man's rights, is their rights to an action. So there's a process of action that has to be understood as like one complete action of creating and using a value. Like a cycle, you create and consume a value. That's what the process of life is. It's creating and using things, right? And and the link between the creation and the enjoyment, the creation and the use, can't be severed. So it's what you have a right to isn't the item per se. I mean, in a way, it's the item, but it's that the one who created it is the one who controls how it's used. It's the connection of the two parts of that action, which are like part of the cycle of human life, right? The action and creation. So it's not that like a plot of land and a log and a symphony are all valuable, so they all can be owned. It's rather they all are products that are used. Products that they all play this role in this process of production. And how the property right works and looks for them depends on exactly how they figure into this process of production. But there's something that's valuable because they're created, and the person who created them gets to use them in ways that he gets to reap the value he created. That's the nature of the right. And then because there's mental and physical in all creation, those two are the components for there to be a property right. And then there's the question of how does each of them factor into different acts of creation. Steve asks if this connects to the bundle theory. Absolutely, yes. So this is the theory often taught in law school classes that property is like a bundle of sticks. So if you have a property right to something, there are a bunch of different, in effect, rights you have to it that collectively are called your property right. You have the right to sell it, the right to rent it, the right to occupy, and etc. And these are a bundle of sticks. You can give one stick to one person and one stick to another person. And property is not a bundle of sticks, it's a tree. The sticks are all connected. They come from one root, and you can, let someone hold on to this twig and someone hold on to this twig at the different branches, but they're all something that forms an organic unity. And the organic unity then has parts, and we can distinguish out the parts, and you can rent your flat to someone for a little bit of time and let him borrow your stereo and let him sing your composition on it. But they're not just a bundle of things that happen to be together. There's a kind of natural unity to them flowing from that they're parts of an action that's itself a part of the action by which human beings survive. So that's maybe a little bit abstract, but I don't want to go into explaining the whole bundle of stick view in more detail. So the idea isn't that an idea that's owned is in every way the same, or it's just another thing that can be owned, like a piece of land can be owned. What they have in common is that there's a value there that's created by human action, and that is created in order to be used by human beings in furtherance of their lives, and that it's a material value that's created this way, but created and used through intellectual means. And then when we're talking about the value of an invention or the value of a song or a book, right, when we look at the physical item that is the iPhone, or the score to a symphony, the bound bit of paper that's the score to the symphony, we're thinking, what is the value that's being created by a mind here, and how is it being used? And it's not like the value of the pieces of paper, which were created by the mind that built the factory, and now you can use the paper in various ways. The value comes in the use that you're going to make of it. And so therefore, to be able to control and have it be at the creator's discretion how this value is to be used, the discretion that he has to exercise is not just over where the pieces of paper that the score are written on go and who gets to handle them and read them, but rather what someone gets to do with the content of the ideas that are on that paper, because that's where the value created resides. Ankar, any further thoughts on just at this level of abstraction, what is similar and different between intellectual and physical property?
No, I think what you said is good. I just want to reiterate what you quoted and what she says it protects. These laws protect the mind's contribution in its purest form, the origination of an idea, and that brings in the action element of it that she's stressing, and as we talked about in regard to rights in general, she stresses that this is how you have to think about rights.
Okay, then why don't you take the lead on the issue of how this leads to limits in duration?
So she brings up both the case of copyrights, so the protection of a new creative product, say like At the Shrug or the Fountainhead, to take two of, Ayn Rand was an artistic creator, and the issue of patents. So, and to an invention and the idea behind the invention. And part of what she's stressing is how to think about the different value created. So to quote some of what she says, but intellectual property cannot be consumed. If it were held in perpetuity, it would lead to the opposite of the very principle on which it is based. It would lead not to the earned reward of achievement, but to the unearned support of parasitism. It would become a cumulative lien on the production of unborn generations, which would ultimately paralyze them. Consider what would happen if, in producing an automobile, we had to pay royalties to the descendants of all the inventors involved, starting with the inventor of the wheel and on up. Apart from the impossibility of keeping such records, consider the accidental status of such descendants and the unreality of their unearned claim. The inheritance of material property represents a dynamic claim on a static amount of wealth. The inheritance of intellectual property represents a static claim on a dynamic process of production. And it's this, and it actually relates, I think, to what you brought up, Agustina, in the property status of airwaves, about that when she talks about on a market, if you don't continuously use and make use of in a productive way property, there's people understand that it can be used, it has a value, they want to buy it, and to maintain it at a value, you have to do work, and that in regard to the creation of an idea, there was tremendous amount of work in doing that. But now it's, as she puts it, it's a static claim that it's been created, and there's nothing, unless you're originating new ideas or new inventions, which you then can patent, there's nothing further, there's no further actions being taken by anyone. And if we're thinking of rights as they're protecting the action, and they're protecting when we're thinking about property rights, of productive actions, that there's no more, the act of production has happened. And then in thinking of it as, well, it's there being some kind of time limit, it's both from the perspective of the actual person taking the action has to be able to benefit from this. And that's why, but it's again in the whole context of production. So it's not, well, if the guy happens to die, then the company that's the employee or whatever, and they've contracted with him, it's now the whole property claim is gone, because she's thinking of it in the context of production, but in the context of production of the actual person involved or people involved in the producing of it. So there has to be some kind of way to secure against accidents and so what they've created. But on the other hand, if you treated it like land, and this was part of the Spooner idea, well, it's just like these other things, so why isn't in perpetuity like other claim, other forms of property? There's no action now, and that she gives it's a type of parasitism. It's now you're benefiting from other people's actions. You're not doing anything, and other people are doing stuff, and you're reaping the reward of their actions. But it's, again, I'm thinking of it as in the form of the whole productive process. And now if it's other people taking that idea, moving it forward, making new things with it, building upon it, they're the ones doing it, and they're the ones who should be benefiting. And you have to recognize, and the law then has to make this objective, that both of these things can happen. And that, I think, is how then the goals of the time limits and why there's time limits, and then the exact, as she says, the exact specification of these is there's a lot of factors you have to think about in thinking of what the precise limits are.
I think of it as, for something to be of value at all, it has to be created by mind-directed action, for something to be of value to a human being, created in material form to be consumed in material form. So a process of production always involves an idea brought into material reality, an idea brought into material reality. And if you read Atlas Shrugged and look at the perspective of Daphne Taggart on what she's doing, if you read particularly the scene in the first run of the John Galt line, where she's coming to really appreciate the nature, in articulate, expressed form, the nature of productivity and productiveness and the connection between mind and body. The more you think about that, the more you see this constant emphasis of Rand on the idea put into material form, the idea put into material form. You come up with a value and you realize it in material form. That is what productiveness is about, that cycle. And so if you think about coming up with an idea as being productive, it's only in a context in which you're understanding it as being put into material form to be exchanged on a market and so forth, as part of the whole process by which human beings live. If you just come up with songs in your head and hum them to yourself and that's all you do, that's nice, but it's not productive work. It's productive work if you think, well, I can come up, I'm pretty good at coming up with little melodies. Maybe I can make a career out of this. Maybe I can make a job out of this. Maybe I could engage in trade based on this I'll record them and I'll sell them to people, or I'll write them out and people can pay me a royalty to play them and so forth. So you have to have that idea of a productive process where the idea gets into material form for the thing to be a material value at all, for it to really be of value. And likewise with an invention, what you're patenting are methods of accomplishing something, right? And the idea is not just, oh, I had an idea of how something works or could work, but I had an idea of something someone could do that it would be valuable to do. And for anything you do, there's an idea and then the execution of it. And what the patent is protecting is it's recognizing that almost all of the value add in the process of work that is done with a patentable invention is in the coming up with the idea, not in the later execution on it, although the later execution has to be there. And likewise, the value, almost all the novel add in a novel is the writing of the novel, not the running of the printing press, which is already, covered by the patent on the printing press and the price of the ink and so it's the whole thing is you're protecting the value created by engaging in a certain part of the process. It's not just the idea as such that's owned, but the protection of the value created, the recognition that the value add is in this part of the process, and the protection of the person who did that work to reap the rewards of it. And that's why the role in the process is so crucial. And these ideas of a static claim on dynamic wealth versus a dynamic claim on static wealth, this is why they're relevant here. This is why this is a time delimited right. And then as to the issue of what the time delimiting is and why it's different for different things, this is another one of those questions like how much property can a person homestead at once, how much land, that is, can a person homestead at once, and how long should he have to work it before he counts as owning it. These kinds of making demarcation lines in the law, it's just part of what the job of law is to do, is to look at the full facts on the ground of what people are doing, how they're making values, to recognize that there are ranges here and there's not like one, it's got to be 73 years and 28 years for this kind of patent or whatever, but to recognize that there's a need to draw a bright line in a situation where there isn't a bright line, but there's something that's exists in many fine gradations in reality, but there are reasons why the line has to be somewhere within a range, and then the legislature just has to draw the line. I think the patent and the copyright are very different in this, right? I think it being too long, there's not really that much danger of it being too long in the copyright case, and she's not too concerned about that. And whereas in the patent case, there really is, because patents are inventions, but they're always connected to a discovery, right? And the nature of the process of discovery is such that if I could exclude you from using, my not letting you publish my book is not going to prevent you from writing other books. But if even if I finish my book, it's similar to your idea, and I finish mine slightly first. But if I invent the electric circuit before you, 15 minutes before you, and I own it in perpetuity and won't let you use it, then it is going to stop people from discovering other things they might otherwise have discovered and inventing things on the basis of those discoveries that they could otherwise have invented. We had some questions on IP. Well, there's this.
And we have a couple questions, Paul, about Android and iOS.
Okay, you've any. Do you want to take the iOS Android one?
Yeah, I mean, so I'm not a legal expert, and I think to answer this, you have to be a legal expert. So I can tell you just from a sort of a layman's perspective, but it can easily be wrong. I was suspicious when the Android was developed so soon after iOS that this seemed something like it should get IP protection. But then the question is, so I think, yes, the iOS should get IP protection. And then what you have to study is, did it and is Android compatible with that? Is it a development that does not infringe on IP? Or was there an infringement that was never really enforced? Or was it that there's something that was preventing Apple from getting the kind of intellectual protection they should have been able to get in the first place? And so there's not a legal infringement by Android. It's rather the government defaulting on its responsibility of clearly defining laws that would enable Apple to get the kind of intellectual property protection that it did for creating this new device and new operating system. So I think for sure there's an IP claim there. And then one has to think, how did the law operate in regard to it? And I think there's a variety of possibilities, and you would need knowledge, some expertise, and then knowledge of the actual situation, in fact.
Yeah, there's a whole history here, too, with computer interfaces, right? There's the issue of, did Windows, was the idea for Windows, Microsoft Windows, stolen from Mac OS? Well, actually, both of them were adapting ideas that had already been developed by Xerox in Xerox PARC, but Apple did it first, and then Microsoft came up on it. And why wasn't, I mean, it's often thought that Xerox made a major mistake in not patenting elements of the GUI interface that they could have patented. And if you read books on the history of this technology, it's generally thought that, Xerox didn't know what they had. So there wasn't, in fact, IP that Apple had that Microsoft was infringing on, it seems. But they were things that could have been patented, but then would have had to have been patented by Xerox and weren't. And, I don't know if something similar to that happened with iOS. But then you get all of these claims. People are worried about there being too many patents in software, right? Like too trivial things about interfaces being patented, like Amazon. People think this is trivial. Their one-click buying, I think, is patented, or one of these kind of features, and people think that's too small. I don't think it's too small myself. I'm not sure, but there are a lot of questions here about how exactly you determine what scale and what things are novel, which is, I think, the term that's used in patent law. And here too, I don't think there's going to be one precise place where that line has to be drawn. There's going to be clearly things that would be on the one side of it and clearly things that would be on the other. And there's going to be a need to define legal standards that are somewhere within the area and that are within the zone of reasonable ways to draw the distinction, and that are clear enough and predictable enough that people can then know what will be patentable and not. And we should mention, or I should mention, that none of us here are experts in patent law or IP law generally. Augustina is at least a lawyer. Ankar and I are just philosophers. But Adam Mossoff at George Mason, or I guess it's now Antonin Scalia Law School, is I think a real expert on patent law, and has thought a lot about how to apply Rand's ideas to it, and runs the Center for Protection of Intellectual Property there. And I found Adam's writing on IP law and on property more general really a revelation. Reading him on this has really helped me to understand the nature of property. So I really recommend his articles, mostly in law journals. to people writing, interested in this, and he's the person to really raise these questions to about, details of did Apple infringe on this, or did Google infringe on that? I know Adam regards, and a lot of people around him regard Google as a fairly bad actor with respect to intellectual property, although Apple's not perfect here either. Okay, so that's Paul's question. I forget, we had one question on this, on a specific IP issue from the Facebook group before. Oh, we're already, I didn't even know what time it is. We're already basically over time.
Yeah, I was going to say, yeah.
Well, then there's one question we should take up with this. It was just a second or two. People are asking all these really good questions. The distinction between discovery and invention. Let me just say a word about that. If it's just a discovery, it's not something that's in a material form as a value. It's just a piece of knowledge, which is good and valuable, but it's not a material value, which is what patents create. And so the discovery has to be embodied in a method to do something. And that's what makes it patentable. But I mean, all inventions are, in fact, co-evolve with some discovery. I discovered a way in which something can be done, but it has to actually be now a method, not just some abstract piece of knowledge that's not embodied in a process or machine. And how to actually make that determination is another thing that, there's a lot of details about in the history of patent law. Is something too abstract to be patentable and so forth? And someone like Adam could, tell you a lot about that. Anything else to say about? Well, I think we. Yeah. Thanks, Augustina, for posting Adam's information. Or rather, this. Yeah. Well, so there are a lot of good remaining questions I wish we could get to. We're over time, but I will post, as I always do, a follow-up question. What do you call it? Post on Facebook, and people can add these questions there, and I'll try to field which ones I can over the course of the next few days, and maybe Ankar will too. I don't know, or we'll take them up online next time. Okay, so thank you, everyone.
Yeah, thank you. Bye.